there have been widespread reactions from within and outside the country. In particular, the opposition has latched on to it, threatening fire and brimstone, and concocting all sorts of imaginary scenarios, and generally muddying the waters. In what I will call the theater of the absurd, the main opposition party, the PDP, even suspended its electioneering campaign for 72 hours. Of course, you must have seen and read my reaction to that. I said there's nothing to suspend in a campaign that never took off in the first instance. So much for the opposition's hysteria. Today, I've called this press conference to set the record straight and redirect the discourse. Contrary to what the opposition and their ilk have been saying, this is not about the forthcoming general elections. Neither does the suspension of the CGN signal the beginning of dictatorship. Lai Mohammed Buhari is an avowed Democrat, and this he has proven time and time again. This administration stands firm on the rule of law. This whole issue is about the country's highest judicial officer, the former Chief Justice of Nigeria, being accused of a breach of the Code of Conduct for Public Officers, and the legal and the moral conundrum surrounding that. It's about the suspicious transactions running into several millions of dollars to the suspended CGN's personal accounts, all undeclared or improperly declared as required by law. It is about the Honorable Justice Onnoghen himself admitting to the charges that he indeed failed to follow the spirit and letter of the law in declaring his assets, calling it a mistake. And it's about him refusing to take responsibility. Instead, he has opted to put the entire judiciary on trial. Please remember that Justice Onnoghen has been given the opportunity of fair hearing, but he has been abusing his position and the judicial process by filing frivolous applications and even dodging service of process. And now comes the role of the media. It is quite regrettable to know that the media, we should have led the discourse, has not done so. In fact, a section of the media has taken sides. Several newspapers have written editorials on this issue. Some newspapers have employed rather crude and obnoxious language to push forth their opinions, while others have been more tempered. But curiously, none has written from a perspective that shows that they understand the big picture. What is the big picture, you will ask? In the words of the Right Honorable Sir Alfred Denny, popularly referred to as Lord Denny, then Lord Justice of the British Court of Appeal, he said, a judge should in his own character be beyond reproach, or at any rate should have so disciplined himself that he is not himself a breaker of the law. Still talking of the big picture, some have suggested that the suspension of Justice Onnoghen is a threat to our democracy or even the country's very existence. They are wrong. Again, I go back to Lord Delhi. Himself quoting the words of Sidney Smith said, "Nations fall when judges are unjust, because there is nothing which the multitude think worth defending." Unquote. And the section of the media that I referred to earlier understood the big picture, they would have framed the debate differently, rather than work to inflame passion and help those seeking to muddy the waters. It is quite unfortunate that in the ensuing debate, the talk about due process has overshadowed the talk about the substance. Procedure cannot and should not trump substance. And in any event, procedure was fully followed here. That brings me to the role of the National Judicial Council. Some have argued that Justice Onnoghen's issue should have been referred to the NJC, that's the National Judicial Council, to handle. They would have been right if Justice Onnoghen had been accused of professional misconduct, which is what is within the purview of the NJC. The allegations against Justice Onnoghen go beyond professional misconduct. It is the alleged breach of the Code of Conduct for Public Officers. And only one body is statutorily empowered to deal with this, and that is the Code of Conduct Tribunal. Interestingly, Justice Onnoghen himself has elucidated on this. In various judgments, he upheld the provisions of the law concerning the CCT, that is the Code of Conduct Tribunal. In one particular judgment, which he delivered on the 12th of July 2013, Justice Onnoghen held that the Code of Conduct Tribunal had exclusive jurisdiction to deal with all violations contravening any of the provisions of the Code of Conduct for Public Officers. Let me put this in a layman's language. All breaches of the Code of Conduct for public officers must be handled by the Code of Conduct Tribunal. Pure and simple. In other words, Justice Onnoghen's judgment held that the provisions expressly outstead the powers of ordinary regular courts in respect of such violations. In a case between Ismail Ahmed and Nasiru Ahmed, Congress for Progressive Change, chairman of the Kano State chapter of the party, and Independent National Electoral Commission, INEC, which has been reported by the media, Justice Onnoghen, while interpreting paragraph 12 of the 5th schedule of the 1999 Constitution as amended, as regards the Code of Conduct Tribunal's jurisdiction, held thus, and I quote, "The said paragraph 12 provides as follows: any allegation that a public officer has committed a breach of or has not complied with the provisions of the code shall be made to the Code of Conduct Bureau," unquote. The judgment, which was delivered at the Supreme Court with the suit number SC 279/2012 before Justice Onnoghen and others, also held that the provisions of the law are clearly unambiguous. Mr. Onnoghen went further to say that the provisions are so construed literally, meaning that any breach of any provision of the said fixed schedule of matters of non-compliance with any provision of the code shall be made to the Code of Conduct Bureau that has established its tribunal with the exclusive jurisdiction to deal with any violation of any provision under the code. Is anyone still in doubt that the Code of Conduct Tribunal is the right court to try the alleged breach of the Code of Conduct for public officers levied against the former Chief Justice? Is it not clear that challenging the jurisdiction of the Code of Conduct Tribunal to try him is an abuse of court process? As for those who argue that the Code of Conduct Tribunal is wrong in ordering Justice Onnoghen's suspension, are they aware that Justice Onnoghen himself disagrees with them? In the same judgment I referred to earlier, he wrote, and I quote, "The tribunal, to the exclusion of other courts, is also empowered to impose any punishment as specified under subparagraphs 2, A, B, and C of paragraph 18 as provided in subparagraph 3 and 4 of paragraph 18, while appeals shall lie as of right from such decisions to the Court of Appeal." End of quote. In essence, the Code of Conduct Tribunal was acting within its powers when it directed that Justice Onnoghen be suspended, and the President did the right thing by acting on the orders of the Code of Conduct Tribunal. Needless to say that in many of the cases of professional misconduct against judges that Justice Onnoghen himself presided over at the NJC, judges have been suspended while still undergoing trial. Conclusion. Gentlemen, from the foregoing it is clear, A, that contrary to the cacophony of voices that have been muddying the waters, the Code of Conduct Tribunal was acting within its powers in ordering the suspension of the former Chief Justice of Nigeria. A different set of standards applicable in their countries to Nigeria. We would have been glad if they had been seized of the facts of this particular matter. Their conclusion definitely will not be the same, especially given the standard available in their own countries. Talking about the standard expected of the highest judicial officer of a state, of a country. Thank you.